Hello friends, in the series on income tax cases, today we will discuss a very important issue which is based on enhanced rate of tax under section 115 BBA. As all we know that before 15th December 2016, the tax rate under section 115 BBE was 30%. The demonetization took place in the financial year 16-17. To make the concept of demonetization successful, because the people were depositing cash into the bank account like nothing, the government has increased the rate of tax from 30% to 60% with effect from 15th December 2016. When the additions were made for the cash deposit, the enhanced rate of 60% was levied on the assessee, and for other additions also other than cash deposit, whatever the additions were made for the previous year 16-17 under 68 and 69 family, the revenue imposed the rate of 60%. The question arises that whether the rate of 60% will be applicable from 1st April 2017, that is assessment year 18-19, or from the assessment year 17-18. This issue has been decided by Surat ITAT in the case of Sameer Shantilal Mehta versus Assistant Commissioner of Income Tax, and this case is reported in 129 ITR Tribunal at page number 83, and the date of the judgment is 8th May 2023. In the present case, there was a search on the assessee on 16th August 2016. In that search, some undisclosed income was found in the form of gold and jewellery. The assessee gave the statement that this is the undisclosed income of the assessee. The assessing officer made the addition, and the addition was made for unexplained money including undisclosed gold and jewellery under section 69A, and when the computation sheet was prepared, the rate of tax at the enhanced rate of 60% was taken. When the matter was before the tribunal, the assessee was not contesting the additions made, but the assessee was contesting that the rate of tax under section 115 BBE for the assessment year should be 30% and not 60%. The submission of the assessee was that whenever some increase in rate is done or some change in rate of tax is done, that is applicable from the financial year which is falling after the amendment is made, meaning thereby that when the amendment has been made in the year 16-17 financial year, that rate will be applicable from 1st April 2017, meaning thereby that the assessee has to pay the tax at the enhanced rate from the financial year 17-18, that is from 1st April 2017-18, and the relevant assessment year will be 18-19. In other words, when the tax rate has been increased in the financial year 16-17, that rate cannot be applicable for the financial year 16-17. The assessee relied upon the judgment of Honorable Supreme Court in the case of Commissioner of Income Tax versus Vatika Township Private Limited, which is reported in 367 ITR at page number 497, which also says that when the rate of tax is changed, then it is applicable from the next financial year in which the change is made, meaning thereby that when the rate of tax is changed in financial year 16-17, then it will be applicable from 1st April 2017. Friends, this case is very important from this point of view also, that how the assessee will know up to 15 December 2016 when the rate of tax has been changed, because the assessee was under the impression that the rate of tax will be 30% from 1st April 2016 to 15 December 2016. So what will happen up to that income? So to cover up that ambiguity, it has been decided that the enhanced rate of tax will be applicable from the date 1st April 2017, that is financial year 17-18, or in other words from the assessment year 18-19. At the end of this video, once again I am repeating the name of the case. The name of the case is Sameer Shantilal Mehta versus Assistant Commissioner of Income Tax, and this case is reported in 129 ITR Tribunal at page number 83, and the date of the judgment is 8th May 2023. Thank you, friends.